Good morning, folks, and thank you for joining us on this sunny Wednesday afternoon, or morning even, sorry. Welcome to our webinar on data transfers and cookie compliance. Just want to go through a quick bit of housekeeping before we get underway with the webinar proper. We are recording the session, so if you have to drop off early or anything, we'll be posting links to it on our social media, and you'll be able to share that with whomever you want. If you do have any questions during the webinar, please feel free to put them into the Q&A there that's available. We will do answering the questions at the end. We might even get to some of them during the webinar, but we'll leave the good ones to the end. And but we won't publish the questions, so nobody will be aware of who is asking the questions. So without further ado, I'll hand you over to Philippa.
Morning, everybody, and thanks for being here. I'm just going to change the slide here. For those of you who don't know me, I am qualified in computer science and law. I have 20 years working with governance, risk and compliance in different sectors. I moved to Ireland from South Africa in 2017, so I've been here for nearly 3 years now. And during that time have focused solely on GDPR and cybersecurity compliance work, where before I would have done a lot of agreement negotiation and consultation on big data science type agreements, as well as general business consultation and advice. So yeah, if you want to connect on LinkedIn, here is my link. We mostly deal these days with data compliance work, so that encompasses data protection, privacy, and cybersecurity. I'll hand you over to Liam now.
Thanks, Philippa. So yeah, myself, I have over 30 years experience working in IT, starting as a programmer way back in the 80s before moving into networking infrastructure and security in the 90s. So I've done some work for large corporations, but I've been doing a lot of stuff now for the smaller businesses, as I find I have a much greater affinity with them myself. I also found that in all my years of dealing with people on matters of technology and privacy and that, is that I have the ability to talk to people in plain, simple English. So I don't use any technical jargon or boring legal stuff. So yeah, like my own business, I've been doing it since 2016, cybersecurity and data protection training and consulting, all to do with a business continuity planning, which is suddenly a hot topic again in these recent times. And my company motto is security simplified, that reflects my drive to make sure everything is kept as simple as possible. So, and you have my there's my LinkedIn profile there, as well as my Twitter, which is where I'm probably most active. So we're going to, as I say, talk this morning about data transfers. And there was back in July, there was a ruling from the Court of Justice of the EU in what has been known as the Schrems II case. And this was which struck down the Privacy Shield framework that was governing transfers between the EU and the US. Now, just a quick bit of history on this. So we've had what was called Safe Harbor back in 2000. This was what originally governed all the EU transfers to the US. But then in 2013, a gentleman called Edward Snowden, who had worked as a contractor with the NSA, blew the whistle on the amount of surveillance that the US intelligence services were doing on data being transferred between the EU and the US, and particularly also on spying on US citizens themselves. So when the revelations came out from Snowden, a young Austrian privacy advocate by the name of Max Schrems launched his first case later on that year in 2013. And that case brought down a privacy shield, or sorry, safe harbor in 2015 or 2016, and then in 2016 the EU Commission and the US formed Privacy Shield. So that went into effect then. Now, while the previous revelations from Snowden were, that there was secret spying on people's data, we've become aware that there's legislation in the US like FISA, which is FISA 702, which enables the US state agencies to be able to get access to data on belonging to US companies. So they can effectively get in and look at any data that US companies have on infrastructure that they have in the US of A. And they also brought out another one called the Cloud Act, which enables against US state agencies to be able to spy on or to take a look at data that resides on servers outside of the US, but which belong to US companies. So effectively, the US is spying on, or has the ability to spy on people's data, personal data, anywhere in the world. And it can be anybody's data, it's not just US citizens. So because of these kind of legislation that's out there, that young Austrian go-getter Max Schrems kicked off another court case in 2018. Now, these court cases he brought were actually in regards to Facebook transferring his data to the US, but it was kind of a precedent-setting case, really. So he took the other cases in 2018. It was called Schrems 2, and in July, the Court of Justice in the EU ruled that Privacy Shield is not an acceptable level of adequacy in protecting people's personal data in the US. So it was struck down. So we cannot use Privacy Shield anymore. So now we're into the future. We're in an unknown kind of situation now. So that's just a quick bit of potted history there. So pass you over to.
Yeah, thanks, Liam. I'm just going to put the slides on only here. Our connection is slightly slow today. So what we're looking at is data transfers. Does your business use any of these service providers? Let's have a look here. I'm sure that the answer is yes, you use more than one of these. Okay, so if you do, then you need to be prepared for the assessment you're going to have to do, which we'll explain how to do in a little while. And we will provide you with some links to help you do those assessments. Okay, so as Liam mentioned, we have to look at data transfers now. Liam, over to you.
Yeah, thank you. So, right, at the moment, there is what's called an adequacy decision agreement in place between the EU and a bunch of other countries, which should pop up momentarily. Now, these are the likes of Andorra, Argentina, Guernsey, Japan, New Zealand, Switzerland. The US used to be on that list under the Privacy Shield framework, but as I say, that's now struck down, and they're working on South Korea. So what this means basically is that you are allowed to transfer data freely between the EU, EEA countries and these other countries, without having to do a very deep due diligence on that country's legislation on data privacy, because the EU deems that these countries respect people's personal data and the right to privacy. But where it comes to the likes of the US, which we've already kind of talked about, that because they have the FISA 702, the Cloud Act, and there's some other executive orders that make data protection troublesome. So like we've already covered those in details, but the UK they're coming up with Brexit, and when they leave us at the end of the year, they now become a third country. So, and they have a piece of law on their books called the Regulation of Investigatory Powers Act, which is kind of very similar to the likes of the FISA ruling in the US. So their intelligence services and state services can get access to people's personal data there quite easily. So that makes dealing with the UK after Brexit is going to become kind of difficult. We still have no clear real guidance on that, but it's it's going to be difficult to understand how they might get proper adequacy so we can continue to transfer data to the UK. Australia also have legislation there called in short, it's called the Assistance and Access Act, and what that actually requires companies to do is to provide backdoor access to any kind of encrypted data, which is difficult. It's something that the US is also trying to do. By the way, they've got some legislation that they're trying to pass that does exactly the same thing. Now, again, whether that's technically feasible or not, well, sorry, it is technically feasible, but it won't achieve the results they're hoping for. But all these kind of legislations that make the protection of personal data, it needs to have due diligence or a risk assessment carried out on the transferring of data to these countries to see, is the state going to be able to spy on the data very easily, or do they respect people's right to privacy? So every organization that is in any of these third countries, that, as I say, have to be assessed. So there is a lot of the big companies that we had mentioned on the previous slide there, they would have what's called the transparency reports. We have links to a bunch of those on one of the last slides, so you can check those out at your leisure. So, but as I said, you need to make a very, very detailed assessment on whether it's safe or not to transfer data to these third countries, and you might want to consider: do you need to use a US-based provider? Is there a provider based in the EEA that would offer a similar service, which then doesn't give you this whole headache of dealing with the due diligence that you have to carry out? So back to you, Philippa.
Yeah, thanks, Liam. Before I change slides here, I'm just going to add a little bit to that, if you don't mind, that it sounds like a lot of work to do, and it sounds quite impossible and scary. And I think the message that is going around is to just stop and take stock now, which will explain how to do. It's not to panic about this. There's no guidance from the European Data Protection Board yet. Some supervisory authorities in Europe have issued guidance. There's conflicting guidance out there from them. So it would be my advice to just stop and take stock, as we're going to explain, and not to panic. Okay, and part of that taking stock is, as Liam said, is to assess whether or not you can use a service provider in the EU. Now, in the EEA. Having said that, a business change is always a big decision, and it should not be taken lightly. Okay, so what are we going to do if you must use a US-based company or a third country company and you're not entirely sure of what is going to happen to the data of your data subjects? These are the very basic next steps that I would be advising on. First of all, you identify your groups of data subjects. The reason why we're doing this is because we need to assign risk to these transfers, and we can't assign risk to these transfers or assign a measure of risk to these transfers until we understand the data subjects that are involved. Are there vulnerable data subjects? Who are these groups of people that you deal with in your business? Are they employees? Are they customers? Are they service users that are particularly vulnerable in some way? Do you deal with immigrants, for example, who may be persons of interest to governments in other countries. These are very real scenarios that organizations in Ireland face. So identify your groups of data subjects. Then what you need to do is look at all the processors or service providers in your business and see what data transfers are going between you and those service providers. So you will look and say, okay, for employees, I might use an HR package that's in the cloud. You know, this is the name of it. Go and see where that data is located. You might provide a chat bot on Facebook to your customers. You know, that data is going to the US. You might be communicating with developers or using Slack as another HR type application for internal messaging in your company. You might be using Google Cloud Services for a web app that you host. You might be using G Suite for your corporate email, your organization's email. Back on that slide where we listed all the companies, Salesforce, for example, sales queries, it's the CRM, you might be putting different notes in. There's been a very recent, quite massive data breach of a CRM that had all sorts of information of people inside there. So you need to know your groups of data subjects and map your data transfers and list those third-party processors or service providers on those data transfer maps. Then what we need to do is we need to establish the legality of the transfer to the third country out of the protection of the GDPR. Are we going to rely on an adequacy decision? So back to that list of countries that Liam explained, those are adequacy decisions provided for those countries. Or is there an appropriate safeguard in place, like the standard contractual clauses? You'll sometimes see people referring to them as the model clauses in practice. These are designed these are put together, and designed not to be changed, and they are under review at the moment. BCRs are binding corporate rules, so that's considered an appropriate safeguard. BCRs are usually done between groups of entities that are performing processing activities, you know, to a common goal. So a group of undertakings is the term that's used. We put together binding corporate rules that each entity is signed up to and bound by. These BCRs are registered with a supervisory authority and are recognized as a very, how can I say this plainly, very high level kind of adequate decision over a group of companies. I'm not explaining this very nicely, sorry. Thing that's in my head and that's blocking the thought there is that if you are relying on BCRs that have been ratified by the ICO in the UK, you are going to have to reassess that situation because that might not be recognized. And in fact, I don't think it will be recognized at the end of the year after December. So also make a note when you're assessing the BCRs where they have been ratified or accepted. Okay, so appropriate safeguards, standard contractual clauses, BCRs, codes of conduct. I don't think we have many of those in practice yet, and certifications. I don't think we have many of those in practice yet as well. Or are we going to rely on a derogation? Now, a derogation is something like the explicit consent of a data subject to transfer. So let's just give you a practical example here. Your groups of data subjects, you've got say 500 people that you're transferring data to and from Google Cloud Services. Derogation, like explicit consent, would be explaining to each person every time a transfer is made what is going to happen, and they must consent for each transfer. You're not permitted to rely on a derogation if the transfer is regular. So it really is a derogation. It shouldn't be happening regularly. So we're in quite a sticky situation here if the country does not fall onto the adequacy list, and if there's no appropriate safeguard, and a meaningful safeguard. So you can't just sign standard contractual clauses and go, okay, that's grand, because if you're signing standard contractual clauses with an entity based in a third country that has a law in place, like the ones Liam was explaining, that probably wouldn't be considered an appropriate safeguard. So you really, that's why I say no panic right now, just assess the situation and document what is involved, okay? Again, you might have a situation where you're signing standard contractual clauses with a company not based in the EU or an organization not based in the EU, or you might be looking at, okay, now put that aside. So say you're signing standard contractual clauses with an organization that's not based in the EU, you need to ensure that they have proper EU representation. Not just a brass plaque office. There are many EU reps out there that purport to be amazing services. They would be registered with a company registrar and have like their offices registered in buildings like co-working spaces, you know, that collect the post and forward it onto an address. There are also quite a lot of EU rep services that are currently registered in the UK, which is not going to be adequate after this year. So please don't just rely on somebody saying to you, oh, but we have an EU rep in place, you know, it's grand. Do your due diligence there as well. Now, there are some good links here, and you can get them out of the PDF that I posted in the announcements. The None of Your Business website, there's next steps up there. So pretty much explaining what I've explained here. They add further an assessment to do. So if you're going to transfer data to a US entity, there's a form there that you can put forward to the US entity to fill in. What we'll probably start seeing, sorry, I've gone ahead here, I think. What we'll probably start seeing is entities putting out answers to those questions on the form in any case, so you don't have to ask them. Comparative legal guide. It's a lovely link here that gives you an idea of different countries' laws and how they match up to our data protection laws. And there's the guidelines and derogations under Article 49. So over here where I was saying a derogation like explicit consent, you can get the guidance on the other derogations and explicit consent from the European Data Protection Board. And then lastly, here's the frequently asked questions on the Schrems 2 case. So you can click on that link there and go and have a look at the FAQs. The guidance is still pending. And with that, I will hand over to Liam.
Thanks, Philippa. So we now move on to the cookies. So bear with me, and I don't know why it hasn't come up yet, but basically back in August 2019, the Data Protection Commission did a sweep of 38 websites, and they produced a detailed report there in April and offered, you know, guidance on the on what they found. So basically, the sectors they looked at were like media and the websites they looked at were in sectors like media and publishing, retail sector, restaurants and foods, sports and leisure, and some public sector websites. So, and they were specifically looking at cookies and how these websites were handling cookies. You know, lots of people have seen these cookie banners, cookie notices coming up on websites, and you know, there's various ways of handling them, and you know, that's what the Data Protection Commission was trying to find out. You know, what's going on out there, what's the general run of things, because there was some cases in the last couple of years where that were taken up in the EU in regards to how websites were handling cookies, and in one case, like, they were, you know, dropping cookies on somebody's computer before getting any consent, you know. So that was deemed to be you know, incorrect and should not be done, and the company got fined as a result of it. So the Data Protection Commission anyway wanted to find out, you know, what's the general lay of the land out there. So they did find that of those 38 websites, and they engaged these companies, by the way. They said, you know, we would like to do the sweep. You know, would you like to participate? So you know, it wasn't like something they just did sneakily in the background. They found that quite a few of those websites were putting cookies on people's computers before they get any kind of consent. Some were, you know, some of these cookies you would have, you know, that the cookie notice might say, you know, this cookie is strictly necessary, or this is for analytics, or this is for marketing. And some companies were saying, or some websites were saying that the, you know, a cookie was necessary or strictly necessary when it really wasn't. So, you know, they weren't applying that terminology appropriately. They, there was some had Facebook pixels that were on the websites, like there'd be Facebook likes button, but the thing with these pixels is that they can potentially track somebody across a variety of websites, so they're pretty invasive. Now, what they figured was that the companies hadn't mentioned it on their the forms they filled out for the Data Protection Commission before the sweep. So they think that maybe the companies weren't aware that these like buttons were on their website, so they were unaware of them. But the pixels are kind of invasive. There was 10 of the websites had their consent boxes already pre-ticked, which under the GDPR, which now applies. Obviously, you cannot get consent with a pre-ticked box. It's unacceptable. You have to enable the user or the person to be able to decide for themselves and tick the box using a positive action. One of the websites, their cookie management feature, the one that says I will allow you give you this type of analytics or marketing, I accept those type of giving consent to cookies, didn't work whatsoever. No matter what you clicked, cookies were dropped on the person's computer. So that was a bit of an embarrassment. And I see it an awful lot on websites where they have the cookie banner comes up and it says, this site uses cookies. We assume you're okay with that. Just click here to accept, or got it, grudgingly accept. These kind of you don't have any real option on them. These were quite frequent, and again they're not appropriate really. And finally, then in some of the other kind of cases, it was the cookie banner was actually overlaying the section of the website or the web page where people could go and maybe try and click on their privacy notice or cookie policy, to be able to read what might be behind the cookies, but they couldn't get to it because the cookie banner was blocking it. So, these were kind of some of the. There was a lot more, but these were the kind of the main ones that was picked up by the sweep. And as I say, they produced a report. All these details are in there. There's links there again. If you want to, if you go to the Q&A, you'll see Philip has put in the link for the slides. You'll be able to click on these links to get to these reports and the guidance. But the report came out in April, and the Data Protection Commission said, here's our report. We're going to give 6 months time, and then we're going to start enforcing cookie rules. So if somebody makes a complaint to them about websites handling of cookies, or if they become aware of it on their own volition, they could potentially start getting onto website owners. Now, I don't anticipate them being heavy-handed with this. They're not going to expect everybody to be aware of this whole situation. So if they do come across this, if you have a website that doesn't meet these needs, they'll probably say, hello, we've come across your website, or there's been a complaint. Here's our guidance, go fix it and come back to us. They will be fairly pragmatic on this, I'm fairly certain. There's not going to be massive fines or anything coming out of this unless people are being totally egregious with how they handle their website cookies. So back to you, Philippa.
Thanks for that, Liam. Yeah, I will say, I won't make any remarks on, how enforcement's going to happen. But what I will say about it is that this is easy pickings because, it doesn't require anybody to go into an office or, an organization's place of work. You literally just have to go into the website and you can make the assessment yourself, whether or not the cookies are being handled correctly. So with regards to what we must do with cookies, we've got here some terminology: first-party cookies, third-party cookies, tracking technologies like pixels and SDKs. First-party cookies would be cookies served by your domain. Third-party cookies would be cookies served by another domain, so another website in plain speak. And then tracking technologies like pixels and SDKs. Pixels are most commonly, there's a link here to Wikipedia, you can go and have a look at web beacons, but pixels are most commonly used in the form of like a 1x1 pixel block that's transparent. So it's like a little transparent image that gets put on the website that you don't see at all. That kind of sits in the computer and enables the tracking of, you know, lots of different behaviors of the user on the computer. So a Facebook pixel, you probably find your marketing managers or SEO people or whoever is saying, or advertising people saying, oh, we must put a pixel on the site, Facebook pixel or a LinkedIn pixel. You might not even be aware that your developer or marketing people are doing this. The reason why they do it is because the Facebook pixels and the LinkedIn pixels allow for retargeting. You know, so somebody will come to visit your website and then they'll go on Facebook or LinkedIn and they'll see the adverts for your page on Facebook and LinkedIn, or the adverts for your website on Facebook and LinkedIn. So it's just that reinforcing your presence type behavior. Now, we're not permitted to do that unless we ask for the user consent, but we'll get into that now. SDKs are software development kits. So you'll have technologies like Amplitude is the one that I've been looking at today for somebody to track analytics, you know, user behavior on websites and web apps. So you would connect with the platform and, you know, through APIs, you would put some code on your website and data would flow between you and the service provider, you know, through these kits. As I said, you cannot implement third-party cookies and tracking technologies like pixels and SDKs unless you have consent. Now, first-party cookies are a little bit different because usually, and not generally, usually what we find is that first-party cookies might be cookies that provide functionality on a website. So say you've got a shopping cart installed on your website for e-commerce purposes. Your first-party cookie would be managing things like people putting items in the cart and the payment process, right? So you would say that's strictly necessary because the site can't function without that. The user can't do what they need to do on the site without that cookie being served. So usually it is that kind of strictly necessary cookie served by your domain, and that can be put into a strictly necessary. You don't have to ask for consent. You don't have to provide an opt-out, right? Now, if we're looking at other first-party cookies, for example, we use Matomo on our website for analytics. Matomo would be considered a first-party cookie for us, right? But it's basically tracking users' behavior on our website. Now, if you read through the DPC report and guidance, they have said that they're not going to concentrate on first-party cookies, but we still have to classify that Matomo cookie that allows us to analyze user behavior on the site, anonymously, by the way. We don't tie it to any user ID or anything like that. We have to analyze it and go, is this strictly necessary? It's not. Like, I can't justify saying that analyzing user behavior is strictly necessary for a user to use a site. It's for my interests, you know, to make better business decisions. So they have said in the guidance that we don't have to necessarily get consent for that cookie. We must provide an opt-out. So we would be processing that based on a legitimate interest, and we've documented that legitimate interest. So when you go on our Pro Privacy website, you'll see the cookiebot banner at the bottom, and you'll see a pre-ticked box for analytics, I think it is. And under there, you'll get the information on Matomo, and you can opt out by unticking the box. So we have pre-ticked that box. It's based on legitimate interest, not consent. You can opt out by ticking that box. We have also implemented the technology to respect the do not track signal on the browser. So if the user has put a do not track on, we won't track them through the site. And then furthermore, we have plugged in the code that allows the opt-out on Matomo in our privacy notice, our data protection and privacy notice, where it belongs. So, sorry, I went a bit ahead there again. You need to understand the cookies that are strictly necessary for the usage of your site. You need to understand the cookies that require consent, and you need to understand the very, very limited, tiny amount of cookies that you would be allowed to serve with an opt-out like we've done with Matomo. With regards to language, you can't use dark patterns in your language, so you can't write your cookie banner language in such a way that you're compelling people to accept it. you know, words like Liam mentioned, grudgingly accept, like you're still forcing people to have the cookies. You know, you're not doing this correctly. You can't nudge people in the direction you want them to go. Now, this is a huge issue with a lot of cookie plugins, cookie management plugins, or tracking technology management plugins, is that the default language that they use is not correct. So you have to go in and configure those plugins to use language that would be considered acceptable. Okay, and here we've got a point. Do test the cookie plugin. You might install a website on WordPress or whatever that comes with a built-in cookie manager, and for the most part, they do not work out of the box. They do not work out of the box. They do not work correctly. So please don't be lulled into a false sense of security with your plugins to say, okay, I've installed it, now it works. Generally, they won't be behaving correctly. They'll be dropping cookies before before consent is obtained. Even if you have set it to obtain consent first, the cookies will still be dropped on the computer, and the language will be incorrect. Okay, again here, don't use bundled consent. So we can get consent for a category or a purpose, a collection of purposes. So if my purpose is analytics and I kind of have 3 cookies under that, I can get consent for that purpose, but I can't bundle all the consent into one. So it can't be like a global accept all option. And you must provide a list of all third parties. So that should be included in your data protection privacy notice. And you should indicate the location of transfers and the basis for those transfers. This ties back simply into what we were saying beforehand about the transfers to third countries. It's exactly what we're saying about general data transfers. These cookies are transferring data too, so you need to understand where that cookie is being served from, where the data is going to go to, and you need to justify your basis for transfer. Liam, I'm not sure if you want to add anything in here.
No, I think you've got. I think you've covered everything. Like, yeah, the kind of dark pattern stuff is really sneaky. I've seen, you know, some people might remember the old Ryanair website when they used to say, you know, you want to tick here if you don't want to have travel insurance. You know, they'd already ticked that. You know, they'd already. You know, you've already got the travel insurance in there. You had to tick a box to take it off. Like, you know, that's definitely a nasty dark pattern. So, yeah.
What was the other one you were saying when we were looking at this? The credit card. Oh, was it on Littlewoods? Pay here and then
Oh yes, yeah. The big green button that says, would make it look like, you know, this is to continue this whole transaction, was actually signing you up to a Littlewoods credit card with some ridiculous interest rates, whereas I want to pay with my own credit card is in tiny little piece of text, you know, with it just to the left of the big green button. Yeah. You know, so totally unacceptable. Yeah. It's
nuts. Okay, so cookies. We can help you. What we've done is on the Pro Privacy site, we have coded in a little app that you can use. It's the website Evidence Collector, and it's based on the code provided through the European Data Protection Board. All the supervisor, all the links are there. We do charge a small fee for it because it took us a couple of months to develop it to the point where it's easily usable by the public in its native format. It's nearly impossible to use. We provided the links for that code if you wish to go and try without paying the small fee that we ask for. What the website Evidence Collector does is it scans your website and it will give you the location of the code on the site where all trackers are embedded. So it gives you a cookie report, which you can get for free on a lot of sites. But the differentiation here is it will show you where the trackers are embedded on your site. And the comfort for us is that it's backed by our supervisors. So, I find that to be quite reassuring. We've used it as a tool to make our own sites as compliant as possible, and we do regular checks on the site too. There's a link here for a sample report that you can download. And if you're interested, we will be running a workshop on how to set up cookie bots, which we find to be one of the better solutions on the market. For now, you can register your interest by emailing us. I promise you, I won't spam you. You'll only be contacted to see if you do want to participate in a workshop to install cookie bot, where we can do a step-by-step and you can install it on your own website yourself and learn how to manage it. Okay. So, Liam, I'm going to hand over to you to do a closing now. Thank you, everybody, for listening. I will answer questions after Liam has wrapped up.
Thanks, Philippa. So, there, as we kind of mentioned earlier, from the various US-based kind of organizations, they're required to have these transparency reports available, and there's a link to a whole bunch of them there, which you can check. Say, click on the links and you see what they show, and some of them are kind of quite revealing how much interaction they get from law enforcement and the intelligence services. So that's can be quite revealing. So that's our content for today. If you want to get in touch with us, we have our contact details coming up there. But listen, thank you very much for joining us here this morning. I see there's a question in there which we'll address now in a moment. But it's been a great pleasure to be able to speak with you here this morning. I say we have this recorded and we'll be publishing it online shortly. So if you feel that other people that might benefit from hearing what we've just talked about, please feel free to share that with whomever you want. So,
thanks, Liam. Yeah, I think I'll take this question because it's addressed to me. It says here, Philippa, you said the choice of partner or the transfer must be considered necessary, as in there's no alternative in the EU. How will this necessary be determined? Maybe the US entity is just better and provides better service. Okay, sometimes words come out of my mouth and I don't remember. I don't recall saying necessary, but I'll answer the question anyway because it is very relevant. So let me just go back here and multitask and find the slide where we were looking at data transfers in the future. Okay, so I've got this slide back up again. This is the slide that Liam dealt with when we were talking about data transfers. So this was the next slide here. What must you do if you use a third country company, a US or third country company? Sorry, lots of clicking here. Part of what I was saying here is establish the legality of transfer, adequacy or appropriate safeguards like the SEC's BCRS code certifications or derogation. And if we go to the previous slide here, back to the adequacy decisions. So maybe the word was adequacy and not necessary, I'm not sure. First prize when we were transferring data out of the protection of the GDPR, first prize is an adequacy decision. Okay, so if you can identify that you're transferring data to an entity on this list, you've won first prize, because that is just the best way to have the data transferred. Okay, if you're not transferring data to a country on this list that is considered adequate in terms of its data protection laws, you need to do an assessment on the country that you're transferring to. Okay, before you consider any of the other bases for transfer. You need to consider the laws that are in place, like these examples we have up here, okay? And then use those transparency report links, see how many times that company has been queried or organization has been queried for data, see how much data they share with law enforcement, see what their stance is, okay? So you list the countries that you're transferring to and you do this assessment here. Also use the comparative legal guide for the data protection laws. So you would say, okay, Australia, gosh, there is actually some compelling of the government to hand over information. The UK is quite extensive in its surveillance of individuals, the US as well, and other countries are probably even worse, like countries like China. So if you are going to transfer and it's not an adequate country, you need to look at appropriate safeguards like standard contractual clauses, model clauses, or binding corporate rules. Now, the issue with these is if you've done your assessment on a country that does not have adequate data protection law in place, it is very likely that this contract, the standard contractual clauses, is baseless, okay? And your binding corporate rules are also going to be a problem to some extent, okay? Codes and certifications, let's put out of the way. Now, if you're looking at transfers that are not regular, okay, irregular, once-off transfers, you can look at the derogations and apply those. So if I'm transferring data once off not regularly to a country that's not considered adequate or has insufficient data protection law, I can ask my data subject for explicit consent. Now, explicit consent is a very high standard of consent. You have to give all the information, all the risks that are attached to that data transfer, so that the data subject can make an informed decision as to whether or not they agree to having their data transferred to that country, right? They have to have all the information they need to make that assessment. Now, you must consider in your data processing activity, if that data subject does not consent to the transfer, what are you going to do? How can you transfer the data in another manner? Okay, so we get back to the question where it was, is there about necessity of transfer? This is where it becomes a bit more of a corporate risk decision, where you go, okay, I need to run my business. Maybe this was where it came from, where I said, you know, you have to carry on with business as usual. I need to run my business. It's not a quick decision to change, you know, an entire provision of services. Like say you rely heavily on the Google Cloud for an app. And now you have to transfer over to Azure on Microsoft to European data center. There's going to be a cost involved. You know, with that, you're going to have to get your developers on board. You're going to have to do some project planning, etc., etc. So you're going to look at that and go, okay, the cost is too high for us right now. I mean, in the times that we're in, any extra cost is just an incredible burden for organizations. But you need to document these processes and document the decisions that you're making and have a roadmap for it, because you can't just say, okay, I'm not ever going to do it. You can say, okay, in a year or two's time, this is how I will put aside the funds that are needed for this. We will redevelop, we will sort this out, you know, or get in touch with the service provider you're using and saying, what are your plans? What are your plans? Are you planning to open a data center in the EU and establish an entity in the EU? You'll see on my LinkedIn, I did that with Otter.ai. We used it for transcription services for some of our podcasts. It's an amazing AI processing transcription, far better than the native Microsoft one. And I had about 6 people's, you know, interviews up on there. And I sent them an email and I said, what are your plans? You know, are you going to do something about this, or are we going to have to close our accounts? I got a very rude reply back saying, you know, you're welcome to close the account, basically. So I was like, okay, Grant. Took all the data down. So I had taken the data down beforehand. It's not sitting there. Now, I might do a podcast where I need the interview transcribed because some people find it more accessible to read interviews rather than hearing them. I might then say if I do the interview with Liam, I might say to Liam, okay, can I get your explicit consent for this data transfer to Otter.ai in the States? You know, these are the risks involved. Does FISA apply? Okay, Liam, are you a person of interest in any kind of national security issues? Like, let's consider this. Do you consent to the transfer? You know, it's that kind of discussion that you need to have. That's once off, it's not regular, so I can rely on the explicit consent. But when it comes to the bigger things, you know, like the data, Google Cloud services or G Suite or that, you know, I mean, just the thoughts, like my IT manager background, just the thought of moving 100 or 200 people's emails over onto a new service is a nightmare. Like, you know, you kind of have sleepless nights over those kinds of things. So I think we have to be very realistic about this and say, okay, it's necessary for a business right now to be using the service. You know, we have assessed the risk involved, and here's our roadmap for dealing with it. So I hope that answers the question. Liam, do you want to add anything to that?
No, it was quite thorough, but it kind of also brings us nicely on to the next question we have that popped in there. And thank you for your kind compliments. Would you may put up the companies slide there, please, Philippa? So yep. The question is the companies you showed in the transparency report list are used by hundreds of thousands of businesses in the EU, for example, Twilio, Facebook, etc. Is it that our business will be able to continue using these companies, but we will just have to reveal all in our T's and C's openly, and let our customers decide for themselves. The thing about it is, since the GDPR came into effect, you kind of should have been already mentioning what companies you're dealing with that is processing people's personal data. The transparency principle would apply here, where you have to be open and honest about everything you're doing with people's personal data, and that includes who you're processing their data through. So you should, yes, be declaring that you are dealing with these companies, and as you said, you're going to have to take an assessment of how you're using this company, how they're protecting your data. Is there adequate protections of the personal data in wherever they store it or they process that data for you? So going back to Philippa's answer to the previous one, like that's a whole kind of a process that you need to get underway, start a project, and document everything. You don't have to do it today, tomorrow, next week, but at least get something started on it. But I would always say, any service you're using that you're processing somebody's personal data with, you put it out there somewhere. You declare it on your data protection notice, privacy statement, that you're using all these services. And yes, you may just find that some customers might say, oh, you use Facebook. I despise Facebook. I don't want to deal with you. So, but at least you've been open and honest with them. They should at least respect that, and you should respect their decision to say, I don't want my personal data being shared with Facebook. That's just that would be my take on it.
Yeah, can I add to that a little bit, Liam, if you don't mind? So where we're looking at a service like Twilio would be a sort of an integral part of sending out communication. So say SendGrid does the emailing and Twilio does the texting. That's not a quick and easy change that you can make. You can but there's a piece of work involved there. So, Twilio is kind of hidden in your pipeline of services. So it's quite hard for somebody who is using your services to say, okay, I don't want you to use Twilio with my data. We're kind of like at an impasse here where your business needs to use it, but the user is not accepting it. So you have to kind of have this parallel process in place where somebody's objecting to your use of the service provider. Can you extract that person out of your flow and deal with them manually for now? If it is that important to them, like some people do have huge ethical issues with companies like Facebook. Not that you'd be doing much processing on Facebook, please. Let's just assume you're not. It kind of would be the pixels and the ads, and this is where the cookie management and that becomes so important, that you respect those wishes, and you can do that kind of automatically through the person not giving their consent to have the Facebook tracking in place. But yeah, so I would be assessing that list of service providers and processes and assigning a risk to them, but also assigning kind of like a necessity value. So is this a core part of our business? Is it going to be a big thing to change? See if you've got some quick wins. If you want to make those changes, that's up to you. But again, please document everything that you're using. Somebody's just put on here, just FYI, as far as I know, the new COVID tracker app uses Twilio. Yeah. So you see, there's like a slap in the face for a technology that's supposed to be so helpful to so many. If it's got Twilio embedded, it's got Twilio embedded. And this is also another good example of why it's so important to keep your data protection and privacy notices up to date. You need to be reviewing your service providers constantly and regularly. You're more than welcome to go on the Pro Privacy site as well and plagiarize off the data protection and privacy notice, just a methodology for listing service providers, and you'll see how we have worded our transfers and bases for transfer for now. Yeah, so let me hand over to Liam. Thanks for all the questions and thanks for being here. I hope it was useful to some of you.
Thanks, Philippa. So that's it, folks. As I say, if you want to stay in touch, our contact details were on there on the last slide of the deck, and don't forget to click on the link that's at the top of the chat, which is a link to the slide deck, which we'll download as a PDF. So that's it, folks. Thank you very much for your time today, and I hope you found this useful. So stay safe out there, wash your hands, wear a mask, and we'll talk to you again in the future.